Okay, this is, sorry, there you go. This is People of the State of Michigan versus Jeffrey Cook, docket number 20-803FH. Mr. Cook, you're here today because a bench warrant was issued based on allegations that you're in violation of probation. It is alleged, first of all, that you left the TRICAP program without authorization and before completion on or about March 26th of this year. And that in count 2, you're in violation by failing to contact the probation department since that date. Do you understand the allegations against you?
Yes.
If they're proven true, it could subject you to a maximum penalty of up to 10 years in prison based on your original conviction. You have the right to be represented by an attorney. You are represented by Mr. Austin, who is present. You also have the right to a contested hearing where you could appear by yourself or through your attorney. You could hear the evidence presented against you. You could cross-examine witnesses, and you could present your own evidence. And Mr. Austin, how are we proceeding on this?
Your Honor, it's my understanding Mr. Cook will be admitting to the violations.
Is that right, Mr. Cook?
Yes.
Would you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Mr. Cook, as I said, you have the right to a contested hearing. If you plead guilty, you won't have a contested hearing, and you'll give up the rights that go along with it. That includes the right to have the allegations proven, the right to have the witnesses against you appear at the hearing and to be able to cross-examine them, the right to have this court order any witnesses that you might have to appear at the hearing, and also the right to testify yourself at the hearing if you wanted to. Do you understand those rights?
Yes.
Has anyone made any promises to you to get you to plead guilty to probation violation?
No.
Has anyone used any threats or other kinds of pressure?
No.
Are you pleading guilty because you believe you did violate probation?
Yeah.
Tell me how you violated probation.
When I got to the TRICAPS program, we had discussed this earlier about 90 days. They had tried to tell me 138 days, and I ended up getting on some psych meds, and I seen everybody else leaving, and I just ended up being an idiot, and I regret even walking out the door, but I did walk out the door and I left.
Okay.
I wish I was still there.
And you didn't contact the probation department on or
I
after
didn't
that
know
date?
what to do. I just panicked. So I just kind of like wandered around like a homeless bum for a couple of weeks. It was kind of stupid.
All right. The court finds the plea is understandingly, voluntarily, and knowingly made. It is supported by the testimony. The plea of guilty is accepted. Mr. Cook is found guilty of probation violation. And Agent Russell, is there a recommendation?
Yes, Your Honor. At this point, Mr. Cook and I are getting nowhere. He currently has a PPO outstanding, protecting his mother. I contacted the prosecutor's office and they said that a pending domestic violence is outstanding. As you recall, at his last hearing, he was supposed to appear in person. He didn't. His mother is the person who appeared on Zoom. He didn't go to the PATS program. He was supposed to go to the House of Commons, then he claimed he had allergies, so he did not get admitted into that program, despite how hard I worked to get him a bed in that program. His mother advised me when he left House of Commons that he didn't have any allergies, and she would know, being that she raised him. So then we worked at trying to get him in the TRICAP program. Then I received another call from his mom saying, oh, he has to do jail time after he finishes TRICAP. I said, ma'am, that is not true. I'm not sure why Jeffrey's calling you claiming this. And so the TRICAP program can go up to and beyond the 90 days if there's meth involved, and we're putting you in a meth improved or meth specific program or opiate specific program. But assessments have to be done to see if that is even what the probationer needs. So at this point, we have where in between the last warrant where he didn't show up in court, he went over to Holden House, and Holden House said that he tried to get into their program to avoid going to jail, which he specifically told them, I just don't want to get locked up. And so, because I didn't show up in court, I'm over here now. So at this point, he's not ready for treatment. His source of where he was living was with his mother, and as of April 19th, she has a personal protection order against him. And so any programming that we were able to do, we're not able to do at this point. His guidelines are 5 to 23. The only way that I can see him getting help is incarceration, because we've exhausted all other resources. We've kept 3 programs on the table, and he's walked away from all of them. And the fact that his mother appeared at his Zoom court hearing, that was disturbing in and of itself, because he didn't want to show up in court. So at this time, I can't see continuing probation. His guidelines are 5 to 23. I'm recommending that if we do 12 months in jail, that the balance can be released if he completes the programming, CBT, all phases of the CATS program, AANA, just to get him stable at this point. But like I said, we don't have housing anymore because he can't be around his mom. And so he didn't have a job. I had to use his mom's email because when I even tried to send him the original forms to get him into programming, he needed his mom to do that for him.
I don't
So
know
we're
anything
just
about
at a
computers.
standstill where I don't want to lock him up, but with him even having a domestic violence pending, he doesn't even qualify for residential treatment at this point. And that his probation be revoked without improvement.
Well, I don't think I can do that because he has to have 3 prior technical violations before I can revoke under the new law.
Okay, so if we have the PATS program and we have that he left TRICAP, and then we have the 2 times that he absconded from probation. I don't know if that falls within, because this is his second warrant, time absconding from probation.
Well, I mean, I have that at the original sentencing, I ordered TRICAP, and then I think we changed it to House of Commons. And he didn't go, but it wasn't a PV. The first PV was February 22nd for not going to MRT. And when he failed to appear, I issued a bench warrant. And then at that one, which would have been the first technical violation, I sent him to TRICAP. And then he left TRICAP, and that makes this the second technical violation.
What happened was the first technical violation was PATS that he didn't go to. The first one was we switched TRICAP to the comments.
Mr. Cook, stop talking. I can't listen to 2 people at once. I'll give you a chance to talk.
So originally, we sentenced him to TRICAP. We couldn't get him into TRICAP. So we pretty much had to wait for a bed space to become available. So you said that we could switch to the House of Commons. Then he went over to the House of Commons, was about to be admitted into that program. And then he started claiming that he had ailments that he did not have. So then I went.
But that TRICAP was originally what I sentenced him on. And then we switched it to House of Commons. It wasn't a probation violation.
No, the first probation violation is that he did not enroll in the PATS program for MRT.
Right.
That is the first violation where I was able to bring him back to court.
Yeah, that's the first one. Okay.
Exactly. And then he didn't appear in court at that first hearing, so he went on absconder status.
Right. He still only has
Then
one
we put
technical
him in
violation.
TRICAP. So I guess we would be at the third violation if technical violations don't count for them not appearing in court.
No, a violation has to be a probation violation, hearing, where he either has a hearing and he's found guilty of probation violation, or he admits to it by way of a guilty plea. It's not just failing to appear for a show cause.
Okay, so the first one would be the PATS, the CBT he didn't go to.
Right.
The next one would
Is
be,
this
I
one.
guess, this one for TRICAP.
That's my point. Yes,
Okay,
that's my point.
So
This is
now-
the second technical
Okay.
violation.
yeah, so it's starting to get confusing.
So for a second technical violation on a felony, I'm limited to a
Would
30-day
be the
sanction. I cannot
TRICAP.
revoke. Okay, Mr. Austin, I'll hear from you.
Yes, thank you, Your Honor. What I can say is that with my
you hear
interactions
me?
with Mr. Cook, they have been, different this time around than my previous ones. The previous interactions I had with Mr. Cook, it was mainly filled with excuses. What I can say is when I talked to him about this particular situation, that is not what I was getting from him. As he indicated to the court, he should still be TRICAP. He wishes he was still at TRICAP. That was actually the first thing Mr. Cook said to me when I talked to him about this. I never even had a chance to even ask him any questions before he blurted that out. I think he's at a point of realization here because after he left TRICAP, he literally, I think, walked back from TRICAP back to here only to find out that he...
I'm sorry, Your Honor. Can you hear me now?
Yeah. Mr. Austin was speaking? Go ahead, Mr. Austin.
And Mr. Cook returned here only to essentially, find out that he's burned all of his bridges. And I think sometimes when you really, hit rock bottom, like that can really be an impetus for change. And I think that is the point where Mr. Cook is at. And I would ask the court to take that into consideration and to continue him on a term of probation, where hopefully I think he's going to take this opportunity and do what he needs to do. He has expressed to me that, he wishes that he had stayed at TRICAP. He wishes that he had completed TRICAP. He knows that that's what he needs. That is the help that he wants. And I'm asking the court to see that and not sanction him any further with any further upfront incarceration and to continue him on probation. Thank you.
All right, Mr. Cook, was there anything you wanted to say?
Mr. Austin summed it up very well for me. I walked 88 miles back home from TRICAPs, like hand and foot, slept in a tree, made a hammock. I mean, it was soul searching, and everybody I thought that cared about me pretty much didn't care about me, and the friends that I thought I had, they weren't friends. And really, I just want to get on with my life and do right and get this behind me instead of going backwards and keep going through this revolving cycle. I just want to get it done and over with. That's all, Your Honor.
All right, well, the legislature decided that they know how to sentence you better than I do. And I cannot revoke your probation despite this situation, or we tried multiple things, you don't do them, you walk away from TRICAP. So I am continuing you on probation, and for this violation, I am sentencing you to 30 days in jail, and I will suspend any of that 30-day jail time that is applicable if there is an inpatient treatment program that will take you. I don't know if TRICAP will take you back or if there's another option. If there is, and we can get you into it, then I will suspend that jail time. But if
There's
not,
one right across the street.
But, Mr.
And I'm
Cook,
allergic,
please, stop it. I'm talking.
Okay, sorry.
If there's one that'll take you, it'll suspend your time. If there isn't, then you have to do the 30 days as your sanction with no earned early release, and you'll be on continued probation with all the terms and conditions of probation continuing to apply. You have the right to file an application for leave to appeal your conviction and your sentence in this matter. You're entitled to an attorney at public expense to assist you in doing that. If you're making a request for one, you have to make it within 42 days of today's date. It will explain that more on the form that we will send to you out at